my boss?
Is
Is it on? Okay, I'll. Okay. All right, I was trying to start us right on time. I so appreciate, all of the board being available and Dr. Melton and her staff. Since we have 3 new members and even all of us that have been around a while, I think we can, as a teacher, I know that we continue to get education, no matter how many years we've taught. So I think that it's a well-planned, meeting. Before I'm going to ask Mr. Lovelace, he wrote up a little introduction to our presenters, and I'm going to let him read that because I was afraid I was going to be a little late from school, but if you don't mind, Ken.
Yeah, we've asked White and Story LLC to come in. I know that 2 partners, Cynthia White and Ashley Story. I don't think Ashley's here today.
She's not. She's actually being installed as president of the Richland County Bar Association this evening. So
Cool.
that's where she is.
White and Story sponsored for the South Carolina School Board Association's training and participated in the board member training at the South Carolina School Board's annual convention, usually held in February of each year. Since COVID, we're uncertain as to when that conference will be held and if it'll be done in person. At least I am. Nikki Gardner was put in charge by Jan to set this training up. And I think she talked to Scott Price, the general counsel for the South Carolina School Board Association, and they recommended White and Story to come to us for training. Here with us today are Scott Winburn and Molly Flynn of the firm. And I guess I'll turn it over to Andrea White from here on to train us.
Thank you. I've got a handout of our PowerPoint, so I'm going to give everybody a copy of that before we get started. See, I can write on it.
I'm not going to believe this, I'm a teacher and I don't have a pen. I usually have 100.
And before we get started, because Molly's actually going to be the one who speaks to you first, but just to tell you a little bit about myself and the law firm. I have a long history with School District 5 actually, and I was doing work for you all back in the late 80s, early 90s. And so, in terms of institutional knowledge, mine goes back probably further than anybody in the room, just in terms of knowing about the school district. And have very much enjoyed working with board members and with members of the administration over the years. I've been practicing law now this is my 33rd year, and I have represented school districts the entire time. And we represent school districts all around the state of South Carolina, both large districts, small districts, rural districts, urban districts. And one of my favorite things to do is actually to train school board members on what their duties and responsibilities are, in particular how they interact with the administration, and to talk about some of the legal issues that you all need to know about to make sure that you don't find yourself on the wrong side of the law, which can impact both you and the school district. So the way that we have set this up this afternoon is Molly is going to talk to you first about the general powers and duties of school trustees, and we've set it up as here's what the board does, here's what the superintendent does, so y'all can kind of see under both state law and in particular board policy how that works. Then I'm going to talk about the Freedom of Information Act and some of the questions that you might have asked yourself or you've heard others ask about, well, can we do this without violating FOIA? When might I have to turn over a personal text message or a personal email using my personal equipment? Then Scott's going to talk about the code of ethics for school board members. And so he will give you some guidelines, as particularly with the convention maybe coming up in February, what you can and should do to avoid inadvertently violating the Ethics Act. And then I'm going to take back over and we're going to talk about some potential landmines
for school trustees, particularly if you've never been a trustee before, which I know 3 of you are brand new, were just elected in November, and that's going to be interactive. You know, I'm gonna pose some scenarios and we're gonna talk about them. As we're speaking, you know, I like for this to be interactive, so if you have a question or want to make a comment, I'll just raise your hand, and then, you know, I'll recognize you, and you can ask your question, and could be I answer it, it could be the 3 of us answer it. It just kind of depends, you know, on what the question is. And we'll plan on taking a break probably after Molly does the initial part of the presentation. If anybody needs a break, I'll just ask if anybody, you know, needs to go to the restroom or needs to check their phone, that kind of thing. And if we can't, I understand we have an hour and a half for this afternoon. If it turns out that we don't get through everything, then certainly we can reconvene at a time that's convenient for you all to talk some more about all of these topics, or if we don't get through, say, all of the potential landmines, that we'll have the opportunity to do that. So I'm going to turn it over to Molly. Just to give you a little bit of background, I told you about myself. Molly formerly worked for the 5th Circuit Solicitor's Office as a prosecutor, and you've been with us now 2 years?
A year and a half.
Year and a half. And then Scott Winburn, he was in private practice when he graduated from law school, and then we hired him from the South Carolina Department of Education. He worked in the Office of General Counsel for Kathy Hazelwood. And so, you know, he has a lot of experience statewide in dealing particularly with things like educator misconduct, and he also can speak to questions about when might the Department of Education come in and take over a school district. You know, he has experience in those various areas. So without further ado, I'm going to turn it over to Molly and let her start.
While she's getting up there, I was just going to tell the group that this is my teacher mind. Sometimes if and you said this, but I just want to tell the board, if they're on a topic that you've got a question, then I think it would be good to raise your hand and ask it then, because sometimes when you wait, you either forget your question or it gets on another topic and you think of another question and you didn't get one answered. If that's all right with you.
Yeah, we're totally fine with that. Absolutely. So as Adrienne said, I'm Molly. I am a former prosecutor, so I'll try to stand a little bit away from the microphone because I'm a pretty loud person as it is. So if you can't hear me, let me know. Wave your hand at me, and I'll be happy to speak up or get closer to the microphone. But also in the interest of sanitation, I like to stay a little bit away from it. So.
Molly, I'm sorry, did we adjust the mic closer to you? Because Barrett is videoing and we're having difficulty picking up. So if you want to pull it back farther in the room or.
How's that?
Is
Is that good?
Make sure we have.
That's really good.
Is that good?
Thank
Okay,
you.
Great. I'll
Sorry.
stand here. If I start to walk away, you just wave at me. Because I do move about a little bit, so I'll do my best. So first and foremost, you are governed by laws in this state. As you all know, particularly this code section lays out certain things that are the general powers and duties of the school board or school trustees. So things such as you must provide schoolhouses. Yes, that word is still in the statute. Of course, we would call them just schools now. You must employ and discharge teachers when appropriate, of course, call meetings, control school property, visit schools, control educational interests of the district. Obviously, that is a big one for you guys. And charge matriculation and incidental fees, transfer and assign pupils, all of those things. I don't need to read them all to you, but those are all things that are covered in the statute. We're going to kind of break them down a little bit. So first, what is your general role as a trustee? So for the board, you all are to set the vision and the goals for the district, which you have done. You have a mission, you have a vision. You're to develop and implement policies. Of course, you all know that as well, and we've had a lot of additional policies with COVID and virtual learning and things of that nature. I'm sure you're all very familiar with that. You must hold the superintendent accountable when appropriate, of course, vote on superintendent's recommendations, and then also serve as a quasi-judicial body in certain circumstances where maybe you may have a student expulsion hearing that gets appealed to you all, or you may have a teacher termination issue that gets appealed to you all. So that would be the function where you would act more as a quasi-judicial type of body. And then on the other end, where Dr. Melton is as the superintendent, she serves as sort of the CEO or the top executive of the district. And she manages the day-to-day operations of the district, oversees all of the hires,
fire, supervising, and managing of all staff in the district. So, further, you all have several functions. So we discussed one, you may be a quasi-judicial body, and some of that is going to include legislative and policy making. So again, not to beat a dead horse, but you all know you have to approve policies, you have to have second readings before you can initiate them, of course, except in time of emergency, as we all know has happened earlier this year. And adopt those policies and of course carry them out and implement them and hold people accountable to them. And then as I stated earlier, hear appeals from employees and students, things of that nature. And then you also are operational in the sense that you conduct meetings like you are today, a little bit differently normally usually. We're not up here talking to you. And then you have to adhere to these state laws that provide what you must do. And then, of course, Department of Education's regulations as well. And then any board policies that you also have to abide by. And then, obviously, you all know, too, who's been here for a while, you approve the budget. That's a huge part of your role at the beginning of the fiscal year. You all know you, in particular, this district is a very large district. You have a very large budget. And so that can take some time. That can take a lot of conversation, and you all will do that. You will adopt a new budget for the next school year. That's going to look a little different probably next year than it did this past year with funding, or lack thereof as the case may be, and then amend those as necessary. And you all have powers, but it's as a group. So you're to function as a group together to the best of your ability, and take action as a group, not individually. So, first and foremost, your policies do provide that the superintendent, it clarifies for the superintendent that the intent of the board, and what the intent of the board is, and what actions are necessary for implementation of board policy. As I talked about, you all know how to do that. You have a first reading, and you have a second reading. Sometimes you have more than that, and then you will vote on them. And then they will be added to your district policies, of course, and posted to your website. Then you also review and evaluate board policies on it as an ongoing basis. So obviously this year, again, not to belabor the point, but you all will be revisiting some policies, especially some policies that you may have enacted as an emergency under the FFCRA. So some of those policies may need to be removed as of December 31st if that law does in fact sunset December 31st and is not extended. So that would be an example of where you'd have to come back together and actually remove a board policy. And then you will receive information regarding the implementation of any administrative rules to those policies. And so for those that may not be as familiar, in your policies, the policies are a little more general. The administrative rules typically where the meat of all of your policies are. So for example, in your Title IX policy, which I'll just use because I've been doing Title IX in my sleep since June, it seems like, you have a general policy that lays out what is the process for a student or a staff member who wants to file a Title IX complaint. But in the administrative rule to that policy, which is JIAA, there is the actual full grievance process, time periods, things of that nature. So typically that's where you're going to find the bulk of the information are going to be in those administrative rules.
Do y'all know what Title IX is for you new school board members? It prohibits discrimination on the basis of sex.
Thank you. Yes, ma'am.
Yes, ma'am.
Okay, so, do we approve or not, are we involved in the administrative rules since it is part of the policy or not?
It depends. So sometimes you all may want to review those administrative rules. It really depends on what the policy is for.
I know we've got their board policies there, and Dr. Melton, you can probably speak to that. I know in most school districts, the administration presents those as information to the board, as opposed to the board actually approving those. They're presented as information. Is that what you all have done here?
Yes, ma'am, that's consistent with what we do. We present as information.
Okay. I know, some school boards have put in their policy that the board will actually approve administrative rules. Now, they won't necessarily go through the multiple readings. They will simply give those one reading and then approve them. But currently, y'all are in you know, where the superintendent presents them to you as information, and so you would not specifically vote whether to approve those or not. The administration has the discretion there.
Thank you. Good question. So next, you all have to conduct meetings. You all know that. So all of your duties that are imposed on you are going to be executed at a lawfully called meeting, such as you have had several of in the last month or so. You will then establish through policy your guidelines for meetings. So if you have a question about how your board meetings are supposed to be conducted, what the agenda is supposed to look like, how far in advance you're supposed to receive the agenda, those things are also going to be in your policies. So if you have a question about that, definitely consult the policy first. And of course, when appropriate, bring it up to your fellow board members if you have an objection or if you have a problem with it, or if you just have a point of order you'd like to discuss. And then your officers, so those of you that are the chair, the vice chair, the secretary of the board, you will work in consultation with the superintendent to develop that meeting agenda. Then you have a process, again, it's in your policies, in place for other trustees, for you all to have input in the agenda. So if you, for example, had a point of order you'd like added to the agenda, in the policy provides for how you should do that, how you should let the superintendent, the chair, the vice chair, the secretary know, so that that can be added to the agenda before it is published publicly. And then, last, you will receive that agenda and your materials in adequate time to review before board meetings. Of course, that's in a perfect world. We all know that sometimes things may slip, but when Andrea is going to talk to y'all about FOIA, this is something you really need to try to adhere to as much as you absolutely possibly can. And when in doubt, put it on the next meeting's agenda if there's not enough time for you all to have reviewed whatever it may be that needs to be added to that agenda.
Could I
Yes,
ask, just best practice? I know we've always, and now that we get it online, but I've been here when we got it by paper, and it was always delivered like on a Thursday afternoon, Dr. Melton, even way before you were here. And a lot of times, and so I just wanted to see what other districts might do. A lot of times, if you work, and if you're retired, you could get it, when you have that evening. But a lot of times, if I got home at 5 or 5:30, I really don't study it Thursday night. You may have something on. So Friday's your day, but if you work, so I always used to worry that the only day I had to call and ask a question would be Monday. Because it might be a question to the financial office, might be one to the superintendent. Anyway, but I really put a priority on staff and knowing how much they have to get together and all they're working. But is that pretty standard that board officers get it like on a Thursday for the Monday meeting? I'm just seeing what if other districts do.
It usually is in a district, depending upon the day that they have their meeting, that they get it 2 business days ahead of time. So if you get it on a Thursday, that would be, a Thursday afternoon, that would be Thursday, Friday, and then of course you've got the weekend.
Got Monday.
But that's what most districts across the state do. Now, it could be that if some additional information, the superintendent gets some additional information that speaks to one of the items on the agenda, that you might get that Monday morning. And there are cases where you might come into a meeting on Monday and be given information by the administration. But what I have seen trustees do, if that happens, and it's, let's say it's a voluminous amount of information, then what could happen is when the agenda comes before the board for approval, and that item is on the agenda for discussion or for action, that if a board member felt like he or she did not have adequate time to review that new information, there could be a motion to move item 1A under the discussion section of the agenda to the next meeting, in order to allow the board adequate time to study. And then, of course, that would need to get a second, and it would need to pass.
Right.
But that's how boards generally handle that.
Thank you.
All right. So you also have a lot to do with the personnel that work in this district. So you actually, whether you know it or not, you actually employ all certified staff members based on a recommendation by the superintendent. And this does look different kind of everywhere, but typically the superintendent will recommend to you all, this will be on an agenda at a board meeting. You will know ahead of time who it is that is being recommended for hiring, whether it's for a teaching position or an administrative position, and then you will all vote on whether or not to approve that recommendation.
And in
from the
this district,
superintendent.
y'all actually vote on support personnel. Those come to you upon recommendation from the superintendent, pursuant to your policy. Some districts allow the superintendent the discretion to hire support personnel, and that's fine for boards to do that via policy. But ultimately, there is a state law that says that no employee, and it doesn't confine itself to teachers, that no employee shall be employed in the district except by vote of the board. So in districts where they have given the superintendent the authority to hire support personnel, the board then ratifies that employment at a subsequent meeting. So even though the superintendent has the authority and she could sign the letter of agreement, that's issued to that person, the board has to ratify it. And, I've had situations before in a district where the superintendent had hired a teacher assistant and issued a letter of agreement, and then it came before the board for approval. Well, in the meantime, between when the superintendent provided the letter of agreement, it was found out by the administration that the person had lied on their application and they had something bad in their history. And so the board could then fail to or act to nullify the hiring of that person, and then that person would no longer have a job, and they would have no legal recourse because it's made clear through policy that ultimately the board approves the hiring of those individuals.
And I will speak to that as well. So you may run into a situation where there has been a recommendation made before you all, but you haven't taken action on it. And in the meantime, because this has happened, it is found out that there is something bad. There is a violent crime on this person's record, for example, which of course prevents them from being employed by the district. So that the superintendent may have to come back to you and say, I'm going to withdraw my recommendation, or I'd ask that you not approve it as well. And then, of course, you will also conduct hearings on any recommendations for terminations for certified staff by the superintendent. Those are obviously a little bit tougher than the hiring, but this is your quasi-judicial body sort of part of your role. You'll hear employee grievances. Sometimes that is discretionary, so you may not hear every single one.
And it's up to you all with employee grievances, okay? And the employee grievance policy, which is GBK in section G of the policy manual, it speaks to when an employee can file a grievance. And in order for something to be considered a grievance, okay, it has to arise out of policy. So it could be a violation of policy by the person's immediate supervisor, a misinterpretation or misapplication of policy, or deviation from a policy. For example, let's say an employee was transferred by the superintendent from one school to another in the district, and your transfer policy says that before the person may be transferred, there has to be a consultation with the employee. I'm talking about an involuntary transfer here. There has to be a consultation with the affected employee. Superintendent, according to the employee, didn't do that. So the employee files a grievance, and it works its way up the chain of command. In the case I've just described, the initial meeting would be with the superintendent because she made the decision. Now, it could be a decision that the principal made. For example, grade level assignments or subject matter assignments. The ultimate, within that grievance policy, it says that ultimately, once they've exhausted the lower administrative levels, that person can request to be heard by the board. But the board, under policy, has discretion whether or not to hear from that person. So the board could review the documents from the administrative levels, the actual grievance itself, and the answer to the grievance and so forth, and then decide you do not wish to hear from the person. That has to be by vote of the board, okay?
Or the board may say, you know, this sounds like there may be something here that we need to take a look at. Why wasn't policy followed? Was there some exigent circumstance? And in that case, the board may actually vote to hear from the grievance. So that, it ultimately is discretionary with the board. You also may have employees who file a complaint, okay? And let me say this, it doesn't matter whether the employee actually uses the grievance form that is provided as an exhibit to the grievance policy. They could write a letter and say, you know, I believe that this particular policy has been violated, and give the reasons for that, okay? And then we could ask them to fill out the grievance form, because it says what relief are you seeking and so forth, but they don't have to do that for it to be treated as a grievance. But let's say you have an employee who, they may put it on the grievance form, or they may just write a letter, and the subject of their complaint is that their principal is not assigning them to after-school duty that they like, or they keep being assigned to the same after-school duty, or you know, duty at lunchtime during the school day. They don't get to rotate in and out of various duties. And there's no policy that addresses that, okay? So that is not a grievance, but that is an employee concern. So that would not be handled through the grievance process. What would happen would be much less formal, where the principal, if that's who the complaint is about, would sit down with the teacher and try to work that out, and then say to the teacher, if you're not satisfied, then you can ask to meet with the director of human resources, or you can ask to meet with the superintendent. But those employee complaints that don't meet the definition of a grievance don't come up through the channel to the board. Okay, so those are handled by the administration, whereas if it's a grievance, ultimately it's up to the board whether or not to hear it. And the reason for that goes back to what? The fact that y'all set policy, right, and then you expect your administration to adhere to that policy. So that's the difference, which is not to say that you wouldn't have an employee asked to be heard by the board, you know, outside of filing a complaint or outside of filing a grievance. And does the board have the authority to hear from a teacher or a member of the public? Yes, you do. You have the discretion to do that. And you, depending on what the subject matter is, it may have to be open session, or it may be executive session. So you have the authority to do that. However, I would caution the board about getting involved in hearing every single employee concern, because if you do that, those things are going to potentially skyrocket, and so you'll put yourself in the position of having to meet to decide whether or not Ms. Smith should be teaching 3rd grade English, or should she go back to 4th grade. And that's not what, first of all, that's the day-to-day operations of the school district, and something that's not in your lane. Plus, you can imagine your meetings will last well into the wee hours of the morning if you got into hearing those kinds of things. So can you do it? Yes. We advise against doing it for the reasons I just talked about. And then, of course, if you hear from one and you don't hear from another, then what could happen? You could be accused of discriminating, right? I heard from this person, but I'm not hearing from this one, and that can create problems for you all and for the school district.
Yes, consistency is certainly key there. And I would note that these are grievances, of course, based on policy, as Andrea said, or an employment concern channeled through the district. These are not grievances that are filed with the Equal Employment Opportunity Commission or the South Carolina Human Affairs Commission. Those are outside grievances. They would not come before you. The administration handles those.
And generally, the administration, when there's a grievance, will make a recommendation to the board. And this depends on the specific district, whether or not to hear the grievance. You know, I've got some superintendents who say, I'm gonna present all the information to the board and then let the board decide whether or not to hear it. I'm not gonna recommend one way or the other. And sometimes, depending on what the subject of the grievance is, legal counsel will get involved to give an opinion to the board as to whether or not to hear it. Because sometimes you've got an employee who simply wants to be heard, and if they're heard, then they'll let it go. If they feel like they've had the opportunity to be heard. Otherwise, they might do what? Go file a complaint with the Human Affairs Commission, the EEOC, or go file a lawsuit. But in other cases, you may know that no matter what you do, this person is still going to go to the Equal Employment Opportunity Commission or go file a lawsuit. So you kind of have to decide, well, is it worth us hearing it? Because that way we will have some information about it, so we'll know when we get this complaint from the EEOC or we get a lawsuit what's going on. So you really have to take those things on a case-by-case basis, depending upon what the subject matter is.
So you also have the duty to promote good working relations with the staff through the district's chain of command. So of course, that's ultimately from the top to the bottom, starts with Dr. Melton and goes through her staff at the district office level, human resources, finance, operations, all of those things, and then down through into each individual school. And then you also conduct an annual evaluation of the superintendent, and that is also provided for in your policy, what that will look like, what time of year that is supposed to occur, and how long you all have to give her the results of that
And her
evaluation.
contract specifically addresses what the evaluation process looks like and how goals are set and so forth. So that is in the contract that you have with the superintendent.
So Dr. Melton's evaluation may look a little bit different than someone in another district, for example, because of that.
Depending on what instrument you use, and under her contract, she is to present the board with an evaluation instrument, right? And then you all look at that and decide whether or not, what her contract says is that you look at that instrument and you attempt to reach consensus with her on whether this is the instrument that's going to be used. Ultimately, it is up to the board what instrument is going to be used, but her contract requires that before y'all say, nope, not this one, we're gonna go with this one, that you attempt to reach consensus with her. But ultimately, y'all get to decide, and there are various districts around the state use various methods of evaluating the superintendent. There's all kinds of instruments that are out there.
And we're happy to help if you need help with that. So next, your community relations. All of you who have just run, you're very familiar with this because you've been out in the community recently. So you all know that you serve as a liaison between this district and the community that you represent. And ultimately are to uphold what you have said to your constituents that you're going to do as a member of this board. You must actively participate in programs that build good community relations. You must also appoint advisory committees when necessary, when appropriate, of course, to outline their responsibilities. So for example, of course, we know this year with COVID, we had bukus of advisory committees to decide what should we do, right? Especially at the end of the last school year and of course throughout. So that would be an appropriate example of when you would want to form an advisory committee to determine what action you may want to take as a board as a whole. You also are going to look to the district spokesperson to communicate with the news media. That is Ms. Goggins. You all know her, I think. And then you also are to channel those complaints and grievances from your constituents through the appropriate channels. Yes, ma'am.
Okay, one question on the other one, number 4. BEDI says will refer information seekers to the board chairman. So do we have an inconsistency?
It depends on, so if your policy, and I know I've got a copy of it right here, let me look at it. In some districts, it is to the board chair, okay? In other districts, it goes to, in a small district, to the superintendent or to the public relations person for the school district. I will say this, what I think creates problems for a school district is when you have individual board members going out and speaking when they are not authorized to speak, either by virtue of what's in policy, or the board may vote to appoint somebody as spokesperson for the board. Now, having said that, let me also say that when you become a school board member, you don't lose your First Amendment rights, okay? You still have your First Amendment rights to speak out on whatever you wish to speak out on. So just keep in mind that even if you say I'm speaking out as an individual trustee and not on behalf of the district, that the public is still likely to view you as speaking on behalf of the board. So it's just something to keep in mind. The idea is to have a consistent message going out, right, about the actions of the school district or a response to a complaint or a concern. And you can imagine if you had 7 different people, plus the superintendent, plus the public information officer answering questions, that can lead to, well, what really happened here? Who's telling the truth? Are we not getting all of the information? So my recommendation to districts has always been that it be the chairperson or the superintendent / public relations office. I just think that makes it more consistent. But if a board member goes out and speaks, or they may be violating board policy, right? If board policy says the chair or the public information, are they violating the law? No, they're not, but they could be in violation of policy.
Okay. So the policy as it exists today, if I read it right, says it should go to the chairman, and then the chairman could decide to involve the superintendent and the staff and all that. But as it stands today, we would go to the chairman.
Right, and then the chairperson, if it's something that the chairperson can't, because she may not know the ins and outs and how to respond to a question. So what I say to chair people is that they would say, I know that our superintendent has been looking into this, and so I'm gonna defer to her to respond to the questions that you have. Now, sometimes the board chair may feel the need, if it's something about criticism of the board or something specific to do with the board, then she or he would speak out about that.
Andrea, if I could give the example, and I won't give the details, but we had some calls about something that happened at a school, and I had several, I know some of my board members said they were called by the news and they just deferred to the chair. Well, what I did is, before I made any statement, I called Dr. Melton to get to to our PR department.
Right.
And I looked at exactly what she had put out to the news, because I did not know any detail.
Yep.
I'll only speak if I know what I'm talking
Right,
about with the
because
board.
you don't want it to be giving
No.
an inconsistent message.
No.
Or
And-
looking like you have no idea
No.
what you're talking about. So that is a very good practice.
That's a good example, and it worked well. I simply said, we're following our policy. I just wrote down what she had said, and I paraphrased it, and they were happy with that.
Well, and I would say that in 90% of circumstances, you and any of y'all, if any of you were to become the board chair, that you would provide a written statement as opposed to agreeing to go on camera and answer questions. And I say that to superintendents too, because, particularly with the news media, and I know that y'all have had a lot going on out here recently, right? And you've got reporters who have one take on things, or another reporter who has, a different take on something. And then, of course, you've got the reporters who are all over social media, right? And so if you agree to give an on-camera interview about something, you don't know where that's going, and I think can you do it without violating the law? Yeah, but if you're board chair, I don't recommend that.
Okay. Good advice.
All right. So now we're going to move on to the role of the superintendent and what that looks like with her interaction with y'all just a little bit more. So the superintendent's responsibilities are, of course, implementation of the policies that are adopted by you all, and implementing that, of course, at the district level and then on down, of course, through to each school level. She recommends certified and non-certified employees for hire. We discussed that a little bit already. Recommend certified employees for termination where necessary, and again, that would come to you all in your quasi-judicial capacity to hear that hearing and give them due process. Terminate non-certified employees where necessary, and Andrea spoke on that earlier as well.
And let me ask a question here of you, Dr. Melton. With your non-certified employees who were terminated, I know there is a process by which they can appeal up to you as superintendent. Do you have cases where support employees ask to be heard by the board, and then it's discretionary with the board whether to hear from them?
It is discretionary for the board. We've been fortunate not to have had that situation, but we do have policy in place and we adhere to that. But the board sees for action and for information when it comes to personnel. So they have some information that may be regarding the retirement of an employee. We take that to them for their informational purposes. So we've actually have divided per some advice that we received a couple of years ago.
Right. So it is usually, it would be treated the same way as a grievance, in the sense that y'all would decide whether or not to hear from the support staff member, based on what all the facts and circumstances are.
And then, I think this is a good tie-in to what we just discussed. Of course, the superintendent's job is also to keep you all informed about what is going on day to day in the district, again, from the top to the bottom, so that you all know, of course, in the event that you do get a phone call or the board chair gets a phone call and you need to direct that phone call to the chair and or find an answer. So the superintendent has that duty to keep you all informed. Yes,
Can I ask on that, just for sort of keeping it in the continuity of it, do most boards, so that everybody, you know, think about the superintendent getting different calls from different board members and it getting, you know, overwhelming if there's something going on, would it be best for a question to just be emailed to the superintendent by that individual board member, or should it come through me and then I send it to her, or is it, you know, best practice, what do you think?
You really could implement whatever worked best in your district. I will tell you what a lot of superintendents do, and y'all may already do this, where the superintendent on Friday will send out an email to all trustees about what has happened in the district that week. Good, bad, things that they might hear about, you know, out in the community, things they might see on social media. And then invite board members, if you have a question about this information, or if you have you know, any other question, please call me. So to have a conversation with the superintendent, or please email me, and I'll be happy to answer that question. Now, if separate and apart from that, if you've got a board member who is seeking information from the superintendent, like you, Mr. Hogan, you want to have information about a particular program in the district or an incident that happened at the school, what the superintendent is going to do, okay, and again, I'm saying what goes on across the state, is when that information is provided to you, it's going to go to all other trustees as well, so that everybody has the same benefit. Even though you didn't ask about it, you're going to get that information as well. Now, if you have a trustee, let's say that Ms. Gardner, you know, asks the superintendent to, and says, okay, I want data going back for 5 years on student expulsions for, let's say, drug offenses, okay? And that's going to require the superintendent and her staff a number of hours to go back and research all of that data. Then what she will do is to say to you, as the trustee who asked for that information, you know, I estimate this is going to take 2 days of work by someone within the student services office. And so before I ask my staff to pull that information together, I want to see if it's just you who wants that, or does a majority of the board wish to get that information. And then it would be brought before the board, and then the board would vote whether or not to direct the superintendent to do that.
So you're saying if it was something that would take a large amount of time,
Right.
it should be voted on by the board?
Well, and I'd say you leave that up to the discretion of the administration to say, okay?
I've never.
So I'm not saying that that's automatically what's going to happen, but if the superintendent, and here's where communication is so important and trust is so important between the board and the administration and between you all as board members, because if you lose trust, okay, you can't function. I mean, you can't function as a board, and you can't function with the administration, and ultimately the school district can't function. And that's not where you want to be. So what I would say is that if the superintendent gets a question and she believes that it is going to take her staff this many hours, instead of doing what they normally do on any given day, they're going to have to put all that aside and research all this, that she would say to the board member, I'm happy to ask my staff to do this. However, I estimate it's going to take 2 days to pull all this information together. And so I want before I start doing this, I want you, board member who's asking for it, to bring it before the board to see if a majority of the board wishes for me to take my staff off of this project and spend these hours pulling together this information. Now, hopefully it doesn't come to that. And again, that gets into trust and communication and so forth. But she does have the authority to ask you to say, well, let's see if the whole board wants to do that. And why is that? Why does she have that authority?
Or a group, not individuals.
It's a group.
Exactly.
Exactly.
Exactly, because when you are not in a school board meeting, you're just like somebody on this, somebody living in the community, right? You don't have any greater power and duty when you are outside of this room and outside of a meeting than any other citizen. Now, you have the same, because I get asked a lot by trustees, well, do we have the authority as trustees to make a FOIA request? Yes, you do. You have the authority to make a FOIA request for information. And in districts where the board is not functioning well, and there's kind of a stone wall between the board and the superintendent as to information that's being requested, and hopefully you don't get to that point, but if you do, then you as a trustee have the same right you had before you got on the board, which is to send a FOIA request in asking for information. Now, that's not ideal, because again, you want to have open lines of communication and you want to have that trust, but you do have that authority. And then the district would respond to your FOIA request as a trustee, just like they would respond to any request from the media or from a citizen. Within the 10 days allowable under law, they can charge you for that information, but it is, as you just noted, it's because you don't have any power outside of a board meeting.
I have a question, and I guess it's kind of operational, because I want to make sure that we're doing this in a way that doesn't put an undue burden on Dr. Milton. What I've been doing when I have a question is copying the other board members, just so when Dr. Milton responded, she could just hit reply all. Rather than now she's got to go and provide the information to everybody and select everybody's name. And I guess, is that okay? Is a legal question, I guess, for Dr. Milton, do you like it that way, or would you rather I just ask you directly?
I looked to.
Okay, let
to this
me
team.
say from a legal perspective, okay, we're kind of getting, we're going to talk some more in detail about the Freedom of Information Act. But the Freedom of Information Act defines a meeting. It's a two-part definition. It is a convening of the quorum, right, of a school board to discuss or act upon a matter pertaining to the business of the school district, okay? So that is a meeting. And a meeting can occur in person, like we are here. It can also occur electronically, okay, which is via email. So there is no problem with you if you're requesting information from Dr. Melton, and you go ahead and copy the other trustees on what you're requesting or what your question might be, so that she can respond to everybody. Where there is a problem, and you are not at that point participating in an unlawful meeting. Where the problem comes in, okay, is if other trustees then start chiming in and asking questions and engaging in debate electronically about a certain, because at that point, what has happened? That's now been turned into a meeting, right? And if the media or a member of the public, there's an attorney named Jay Bender. He used to be the attorney for the South Carolina Press Association. Some of you may know who he is. I've known Jay for all the years I've been practicing, and if he was to find out, or anyone else who does a lot of work in the area of FOIA, that was occurring, that is an unlawful meeting for purposes of FOIA. So that's where you have to be careful. It's fine for you to copy everybody and for her to answer everybody, but then for Ken to ask the question or Matt to ask the question, and then that's where it gets to be a problem.
So my question is what happens if that happens? What happens if you send an email to the board and the superintendent, and then someone else responds and starts asking questions, and there is engagement from the board?
I think at that point, it would be up to if either the chair, because you as the chair are responsible for seeing that meetings are lawfully conducted, okay? So it would be up to the chair to say, this is not in compliance with FOIA. We need to wait and have this discussion when we are all together in a lawfully called board meeting. That's how I would handle that. That should come from her. The superintendent could do it as well, but remember, she works for all of you, and she probably wouldn't want to be seen as telling you what you can and can't do, so it needs to come from the chair.
So what we really should be doing is what the district staff does when they send out emails to the board. We should blind copy everybody instead of regular copy, so that you can't just respond Is that
Right,
what
yeah.
you would recommend?
Yeah,
Okay.
either that or just avoid responding. I mean, just,
I
and if you have a question, like, let's say another trustee has responded. See, at that point, it's just the superintendent and one trustee, right? And maybe there's a second one who said something. So you haven't gotten up to that critical four of it being a quorum communicating via email, right? So, but let's say you might be the fourth one or even the third one. I would pick up the phone and call the superintendent or call the other trustee and say, you know, I didn't really understand what you meant by this. Can you explain that to me so that when we have our next meeting, I will understand where you're coming from, okay? Because it's unrealistic to think that trustees are not going to communicate between board meetings. That's just, you know, ideally, would all communications happen in a board meeting? Yes. But in today's world where we're all, even more so now during the pandemic, you know, we are communicating electronically and so forth. It's just unrealistic to think that you wouldn't have a conversation with Ken or you wouldn't have a conversation with Rebecca. But and there's nothing unlawful about that. When it gets unlawful is where four of you are engaging in a conversation, whether it's on a four-way conference call or it's electronically. That's where you have to be so careful.
So to back up, is it all right to ask a question? And I would ask, can we do a regular copy all just because it can't, Dr. Milton, if I blind copy, she doesn't know who I blind copied. You know, and I would say that something about blind copy feels like you're being surreptitious or something. I mean, it's just a perception, but would that be all right? And then she can respond and then we just need to not.
But then everybody else needs to not pick up the phone. If you've got a question, pick up the phone and call or send a separate email, okay? Because I know sometimes it's much quicker to communicate by email. But don't get into this copying all and then this person's chiming in and that person's chiming in because that's where you are not complying with the Freedom of Information Act.
Attorney
Yes.
White, if I could get, I'm sorry.
Go ahead, Stephen.
I was going to give context. Based on legal advice in 2018, after a School Boards Association event, we did shift towards the blind copy, and the message says this email is being a blind copy to all Board of Trustees, and we've cited the policy. We've done that as a staff to make sure we did not create the opportunity for a virtual online meeting. So from a staff operational point, to provide context for the two of you, that's what's being asked, with me giving context as to why we've done it that way. If you're saying that the board can send an email and copy for the ease and convenience of the reply, but from a staff operational, we've tried to be protective for those reasons.
Right, and that makes sense. You know, I think you could do it either way, but what board members have to remember is, you know, resist the temptation to get into a discussion with your other trustees via email, because when you do that again and other people chime in, you're violating the Freedom of Information Act. Plus, you know, even if there's not four, so there's no quorum of trustees discussing it, you know, in my opinion, if there's a lot of that going on, or maybe it's just two or three with the superintendent, what does that create? You know, it creates, in my opinion, a lack of transparency within the school district, and then it leads to questions about, are you really doing business at a school board meeting, which is what you're supposed to do, or are all these background conversations, you know, whether it's by phone or electronically or huddled up at a school board meeting, okay? What are you really doing business behind closed doors, so to speak? Because the Freedom of Information Act is all about doing business in the open. It's known as, you know, the Sunshine Law. So that's just something to keep in mind. So whether you do it blind copy or you CC everybody, what you can't get into is that back and forth.
I have a question about that. Can that back and forth include us trying to get things on the agenda though? Like, if we're actually talking about conducting the meeting itself, not the actual issue, is that appropriate or not appropriate?
No, not with four. Once you get into a quorum talking about what's going to be on the agenda, that's still a meeting, because it's setting the business that's going to come before the school district. So even though it's not the substantive issue itself, it's what's going to be on the agenda to be discussed. So
We don't discuss what's going to be on the agenda in a meeting, so I don't know why that would be.
Well, let me say, well,
it's still, in my opinion, it's still a FOIA violation, okay? For you to talk about even what's going to be on the agenda with all four of you communicating about it via email. The way, ideally, here's how an agenda should be prepared for the board to then bring it up, okay? And again, we're kind of getting into FOIA here, but that's fine, because I want us to talk about this and then we can move on as it's appropriate. Okay, the superintendent, and this is pursuant to your board policy, okay? She prepares the agenda for the board officers' review, right? And then the board officers have input into, we can take something off the agenda, we can add something to the agenda, we can move something to a different agenda, and ultimately it is the meeting of the board, right? But a lot of what you do in a board meeting is driven by information that the administration needs you all to know and needs you all to act upon. So that's why the superintendent drafts the agenda. There should be a policy in place or a practice, and let me look at your BEDB and see if it's in here real quick, by which other board members can have information put on an agenda, okay? Because it's not unusual and it's not particular to you all that other board members who aren't board officers feel like, well, I want to talk about closing a school. I think we need to talk about closing this very small elementary school, but it never gets on the agenda because the board officers don't want to put it on the agenda, right? And so that way the agenda just gets controlled by the superintendent, whoever the board officers are. So what you want to do to avoid that, because the officers don't what? They don't have any more power than any of the rest of you, okay? The chairman has certain duties and responsibilities under board policy, but she doesn't have any more authority than any other trustee does. No officer does. But there needs to be some, here it is, board agendas. There needs to be some other way that board members can request that information get on the agenda. And if you look at your policy BEDB, it says items of business may be suggested by board members, staff members, or citizens of the district. Individual members requesting items to be included on the agenda should make such request to the board chairman no later than 2 p.m. on the Monday 1 week prior to the next Monday board meeting. Now, and that's a good practice. The next sentence, though, could be problematic, okay? The next sentence says, the inclusion of such items will be at the discretion of the superintendent, board chairman, and the board officers. So you might can ask all day long for something to be put on an agenda to talk about perhaps closing the school, but if the superintendent and the board officers don't think it's going to be on there, it's not going to be on there. So what I would suggest is that you take a look, and this policy is now 14 years old. It goes back to 2006. That you look at perhaps amending this policy so that there can be some way in which other trustees can get things on the agenda. Now, it needs to be orderly, okay? Because, 7 different board members, if each one of you has a particular topic that you want to be on the agenda for your meeting in January, let's say, well, that's not feasible, right? Because the administration's gonna have other things that y'all need to discuss or you need to vote on and so forth. But there needs to be some process by which if a certain number of board members want something to be put on the agenda, that it should be put on the agenda. So that you avoid the problem of the board officers just controlling what is on that agenda. And there's different ways to do that we won't talk about because we don't have time this evening. But I would suggest that if that's a problem that has either occurred or that you're worried about happening, that you take a look at the policy.
Andrea, I appreciate that so much because that was one of my frustrations. I mean, I've been on the board a while and it's been a long time since I was an officer. And I would just be very frustrated that our policy did just leave it to that discretion. But I also, now that I am the chair, I care very much about hearing from everybody, but having a process where wouldn't happen, what you just said, where we have 7 good ideas that won't on there, but we can't, for lack of time, can't do it. So if we could, I'd like everybody to be thinking about that, to bring to us those ideas, because we could amend it and have something where you would feel like everybody feels equal opportunity, for lack of a better way to put it.
Well, I know some districts, and I'm not suggesting that you do this, this is just an idea of what some districts do, where at the end of their agenda for a board meeting, there will be an item on there for, discussion for, or items for future agendas, right, for future board agendas. And so what could happen under that particular item was, let's say, if Matt wished to add a discussion about looking at possible school closings, then that would what? There'd be a second, he would make a motion to add that to an agenda. There would be a second, and then y'all would vote on it. And so if 4 people want to add that to an agenda, it would go on the agenda. So that's a way, I'm not saying that's the only way to do it, but that's a way to look at it. So that way, it could be put on the agenda. Now, if the superintendent knows that, well, the agenda for the, let's say, January meeting is going to be very lengthy, she may say, okay, that will be added to the agenda. However, our January agenda is already very extensive because we've got to cover blah, 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 blah. So we will then put that on a meeting, on the February agenda. Or a board member could make a motion for a special called meeting to discuss whatever that topic is. Because y'all are gonna have to look to her to say, is it even feasible for us to talk about that in January? What else is on the agenda? But that's one way to look at doing it.
One question I had is, in the paragraph after that, it says, items of business not on the agenda may be discussed and acted upon if a majority of the board agrees to consider them. I was always under the impression that you couldn't do that because of FOIA had to be the notice.
That's correct. This policy.
So it needs to be fixed.
Yeah, this policy predates the revisions to the Freedom of Information Act. So we'll go ahead and talk a little bit about, and I'm not going to take over here. I've been doing this so long. But, okay, so pre the amendments to the Freedom of Information Act, the rule used to be, and the way that the law was worded, it said, notice of the meeting and agenda, comma, if any, comma, must be posted at least 24 hours ahead of the actual meeting date. Well, a school district in the upper part of the state, there was a topic that was very controversial within that school district. And so what the board did was that item that was going to be very controversial was not on the agenda. Because if it had been on the agenda, all these people would have shown up to talk about, how controversial it was and what they thought about it. So what the board did was, at the meeting itself, they moved to amend the agenda to add this controversial item to the agenda. And I want to say it was not just for discussion, but it was also for action for that particular evening. And so then they voted on the matter, and the public went crazy. Because what members of the public said, well, if I had known that that was going to be discussed at this board meeting, then I would have made sure that I was at the board meeting and that I signed up for public participation, or I at least was there to listen to the board debate it. So that went to court, and the court fixed that problem. And the court now said you must have an agenda for every single board meeting. And that's the case whether it's a regular board meeting or a special called board meeting or a work session, okay? If the board is meeting, you must have an agenda. And that can only be amended, okay, if it is a matter for discussion, it may only be amended by a 2/3 vote of the board, okay? If it is an item and the way that the statute is worded doesn't make a whole lot of sense, but it says final action, okay? Well, the way I advise boards and the way I interpret that is that means if you're going to vote on it, whether it's a final action, a pre-action, if you're going to vote on something, it has to not only be a 2/3 vote, but the board also must find that there are emergency circumstances that dictate that that matter be acted upon at that particular meeting. And when the court says, and when the law says emergency circumstance, they mean emergency circumstance. Like the roof fell in at the high school the night before, or the superintendent has been in a car accident and is in a coma in the hospital. So it truly is an emergency. And if the board doesn't do that, if they don't amend the agenda that way, then they're in violation of FOIA. Because the whole idea is to discourage boards from adding things at a meeting, because again, that's not transparency, because the public can't then come, to the meeting, or they don't know what's going to be discussed. So this policy, that's another reason, that's a good point, needs to be updated.
So it's a good segue into our next slide about how do you get policies brought to you. So practically this may look a little bit different than this information on the slide. So ultimately the superintendent is probably going to work with her chief human resources officer, so Dr. Harris here, to develop these policies. You may also work with the school board association or a law firm like ours or someone else's to help create those policies. But ultimately the superintendent will present those to you all. You again will have that first reading, second reading. You might have more depending on how many amendments need to be made or if there needs to be much more discussion. But ultimately, hopefully within 2 readings, you will pass those policies and then they become active. So again, the superintendent participates in public executive sessions of board meetings except where her contract provides otherwise. So I know Andrea has spoken to specific things that are in Dr. Melton's contract. Andrea, I don't know if you want to speak to that about anything about executive sessions and board meetings with her contract.
Under the superintendent's contract, she is entitled to attend and participate in all board meetings, both open sessions and executive sessions, except when certain things are being discussed. Those things are the terms of her contract, her evaluation, when board superintendent relationships are being discussed or relationships between trustees themselves are being discussed. In those cases, the board has the authority to ask the superintendent to recuse herself from those discussions, but otherwise, she has the authority to attend and participate in all board meetings.
And then she's going to assure that you're in compliance with legal requirements regarding these board meetings. So the agenda, like we just had a lengthy discussion about, she'll identify topics that y'all should be addressing at meetings, of course, hopefully through the agenda, and any other communication that may need to be had. Again, not more than 4 people, so you don't run afoul of FOIA. And then prior to meetings, she should provide you all with sufficient information so that you can make a decision at the board meeting.
And I really like the way that y'all do that here, with you being able to go online and access that. And members of the public can do that as well, to be able to get, that's much better than what a lot of school districts do. So I would commend you with how y'all do that.
It's very transparent. It's very, that makes us who love, hate FOIA very happy. So, and then ultimately, if she will implement decisions from meetings. Of course, if it's a termination or a hire, she will carry out those decisions that you all make. And then lastly, with respect to personnel, we have touched on this, so I won't belabor it, but she will recommend, of course, employment of certified and support staff to you all. We discussed how that's a little bit different here. Recommendations of terminations, of course, for support staff and certified staff. And she's responsible for supervising all employees. So from her, her cabinet, her staff at the district office level, all the way down, of course. And then she does also serve as the liaison between you all and her staff. And that means everybody. And then she is also supposed to help develop a plan for evaluating the performance of district personnel. So of course, those are people who are subject to evaluations, those certified employees. And then delegates the authority to any other staff members as appropriate. So as I said a couple of slides ago, practically, if policies are being brought to you, they may be presented to you by your chief human resources officer. That may be something that Dr. Melton delegates the authority to, but she's worked closely with Dr. Harris to develop those policies, but ultimately allows him to present them to you all. Does that make sense? Okay. All right. Andrea's going to bring us into FOIA, I think.
And let me say one thing too, and this is in your policy BDD, Board Superintendent Relationships, that when you all need information that is housed within the finance department, or, you know, when we were talking about student expulsions earlier, that's within the student services office or within human resources, those requests from you all as trustees should be going to who?
Dr. Moore?
Superintendent, right. And her contract provides for that, as does board policy. So, you know, you all should not be communicating directly with other members of the staff. You communicate with her, and then she gets with that staff member to get the information that you need. Is everybody okay to go straight on forward through FOIA with the break? Okay. Yeah, and we've talked about some of this, but let me stand up now. So, all right, the first thing that I want to cover is meeting goals. Okay, and we've talked about some of this, but number one, sticking to the agenda. Okay, meaning don't bird walk within a board meeting. You know, keep your discussion germane to whatever item it is on the agenda that you're discussing. Number two, and this is the chair's duty, allowing each trustee an opportunity to speak. Because in some boards, and you know, I don't know if y'all have any members who are like this at this point, but want to dominate the conversation, okay? Before every single trustee has had the opportunity to speak. And it is up to the trustee, up to the chair, to make sure that before Rebecca gets to speak again, that Matt has a chance to speak and provide whatever information he wishes to provide before a vote is taken on a matter. And so she has to be the one to police that, so to speak. And if a board member, you know, is constantly raising their hand before another board member, and that person has already had an opportunity to speak, to move on to the next trustee before she goes back to that person. And so it's up to her to see that board meetings are orderly and that everybody has the same opportunity to speak. Providing public participation, y'all do that here. Interestingly, public participation is not required by what? It's not required by state law. There is no requirement in state law that a school board have an opportunity for the public to participate. Now, your board policy has a process in there. And of course that, I don't know how that policy is without looking at it, but different districts handle public participation differently. Most school boards have it at the beginning of their meeting after the agenda has been approved and after the Pledge of Allegiance and all that stuff. They go ahead and have public participation. Some boards push it to the end of the meeting for reasons that may not always be in the public's best interest to move it to the end of a meeting. You know, I like to have it at the beginning, particularly if you've got teachers who wish to speak, or you've got parents, or you may have students. You know, why make them wait till 10 or 11 o'clock at night to be able to address the board? Plus, the other thing is they may be addressing the board about a topic that y'all are going to discuss or act upon later on in the meeting. So wouldn't you want the benefit of, whether you like it or not, you know, to get the information from the public before you discuss or before you act on a matter? So, you know, I encourage boards to have public participation at the meeting, unless for some reason at a particular meeting you simply can't do that. With public participation, you know, some boards look at confining public participation to items that are on the agenda that evening. Other boards say, no, you can come and talk about whatever you wish to talk about. There are time limitations, and, you know, if there's a group of people who want to speak on something, having them designate a spokesperson. But you can address all that through your public participation policy. And then it's up to the chair to police that. You know, you're at your 3 minutes, you're at your 3 minutes. You start calling names, you know, and identifying school personnel, that's out of line. Can't do that during public participation. So the chair has to be the one to police all of that. Reducing conflict. That's the idea of a board meeting, is for everybody to be civil to each other. Everybody has the same opportunity to speak, and reducing conflict both between board members as well as with the administration. Because, you know, you want to be a functional board, and you want the public to view you as a functional board, and each of you as knowledgeable trustees. And so at a board meeting, it's very important for you to remember that everybody is watching you, including students in the district, to see whether or not y'all are functional. So just keep that in mind.
Conducting legal votes, okay, you do that at a board meeting. Number 6, you have the authority to talk about certain things in executive session, right? However, let me say this, executive session is it mandatory or is it permissive? It's permissive, okay? So just because you have the authority under the Freedom of Information Act to talk about something in executive session doesn't mean that you have to do that. Now, obviously, if you're talking about a specific personnel matter, you don't want to be talking about that in open session because of confidentiality. Same thing with student matters. But, you know, if you, let's use legal advice, for example. If you are receiving legal advice, for it to be conducted in executive session, it has to be related to what? A pending claim, a potential claim, or a threatened claim. Just because your lawyer is at a board meeting doesn't mean that you can go behind go into executive session and hear from the lawyer. And I know, oh gosh, this has been back in the mid-2000s. I actually was giving legal advice to the board about the Equal Access Act and student clubs that form on school grounds. Some of you may remember that. And it was the time of the Gay Straight Alliance and whether or not that they could meet on school grounds. And the board wanted me to, and I could have given that legal advice in executive session because we were getting some threatened claims, right? But the board wanted me to do that in open session so that everybody could hear it. So we did that, and I actually spoke publicly. So it's permissive, not mandatory. Should you have an executive session at every single board meeting? No. I don't think so. Some boards routinely have executive session on there. Other boards have it as necessary, but then they always utilize that. And what does that do? If you are always having executive sessions and they always last an hour or longer, what is that doing? Well, it's making the public say, what are they doing behind closed doors? Are we being transparent here or are we not being transparent here? So, you know, I tell districts or tell boards, you know, really think about, do we need to have an executive session tonight? And if we do, can we get business done in 10 minutes or do we need to be back there for an hour and a half? Because if you're in executive session for an hour and a half and then your regular board meeting only lasts 2 hours, you can see why members of the public would say, well, what in the world are they doing behind closed doors? So there are appropriate times to utilize it, but don't overutilize it. Okay, let's go to FOIA.
Andre,
Yes.
on that point, and I just had assumed that, that's the first time I've learned that. I thought of all my 15 years, we've never not had executive session.
Right.
And sometimes it's, you know, lasts the hour, and sometimes we're finished in maybe 15 minutes, and then we just let it go, open the doors, you know, you can go out. But I really didn't know it wasn't mandatory.
Well, it's not mandatory. And because you are only allowed to discuss certain things in executive session, right? There may be meetings where you don't have to have an executive session. Now, you know, at most meetings, you may be talking about somebody leaving the school district or people being hired. You know, those are very legitimate reasons to have an executive session. But, you know, to have it on the agenda for an hour for every meeting, I think can lead to questions from the public about what it is you're doing and why you always have it on there. So it's just something to think about, whether or not to have executive session. And I think y'all do it at the beginning of your meetings, right? And you can do that, and there are reasons to do that, but a lot of boards actually put it at the end of the meeting, okay? So that, you know, again, you can get through all the public business before you get to the executive session. And that's just board discretion. And, you know, at some meetings you could have it at the beginning, and some meetings you could have it at the end. It just depends on what you want to do. But I'm really a proponent of limiting executive session where you can. Okay, the Freedom of Information Act, we talked about this a minute ago, requires public bodies to operate in the sunshine. The other thing that FOIA does is it allows the media, are you hearing me fine? Okay. It allows the media and citizens to obtain copies of public records. So y'all's main attention here is to number 1, requiring public bodies to operate in the sunshine. Your staff generally handles responding to FOIA requests.
So here are some common questions for purposes of FOIA, and I'm gonna ask y'all these, okay? What is a public body for purposes of FOIA? Y'all are a public body.
Subdivision of the state is.
Right, a public body is considered a school board, a city council, a county council, certain governing boards of, and what the statute says is that it is a group that operates in whole or in part supported by public funds, okay, is how it defines a public body. But what about subcommittees of the board? Yes, subject to FOIA. What about advisory committees to the board?
The superintendent appoints it, and it's not appointable, right?
Well, it depends, okay, and let me tell you what it depends on. If the committee that is formed gives information to the superintendent, not to the board, then that would not be subject to FOIA, okay? But if the board asks the superintendent to form a committee for that information to come back to the board, then it is a public body. So it really depends on how the information is being filtered as to whether or not it is considered to be a public body. I will say that in recent years, the past 10 years or so, our courts are very much expanding what FOIA obligates public bodies to do, okay? And I think that our statute mirrors Florida's FOIA statute. And, until about 10 years ago, we didn't have a lot of court decisions interpreting what FOIA meant. But we're getting more and more, and they are more and more siding with the media and with members of the public as to what is considered to be public information and what is considered to be a public body. And I expect that trend to continue as we get more and more lawsuits under FOIA. So we talked about number 3, about the agenda. What is the definition of a meeting under FOIA? Gathering of a quorum to discuss or act upon a matter that is school district business. So if you all, let's say at the convention in February, if it happens in real time, which now it's scheduled to be, face to face, but that could change depending on COVID. But if you go to that meeting, can 4 or more of you go out to dinner together without violating FOIA?
As long as you don't discuss.
Exactly,
Yeah.
because it's a 2-part definition. So if all you're doing is going out to dinner and talking about things other than district business, that's no problem. Can 4 of you, because I mentioned this earlier, can 4 of you gather somewhere in the lobby and talk about district business? No, you cannot do that. And I see that happen. I'm not talking about you all. I'm talking about in general. I see that happen at these conventions all the time, where, like for example, an 11-member school board, there's 6 of them over in the corner gathered together. Now, are they really talking about where they want to go out to eat dinner? So just, even if the 4 of you are together, just be cautious about being seen huddled together talking, right? Because that leads to a question.
So I have a question, and I have no idea if this, I have not received any notice, it's a question, a general question.
Okay.
Can there be, an officers meeting with the officers and the superintendent without it violating FOIA?
I would say that yes, you could, because it's not a quorum of the board. I would discourage that. I just think that, I think it creates a perception that business is being done outside of what should be done during the regular board meeting. Does it technically violate FOIA? No, because it's 3 board members. But if you sit down, this is not in FOIA, but if you sit down and read your policies, right, as to board member duties and authorities and so forth, and the oath that you take as board members, one of the things that's in there is that board members should not have secret or star chamber meetings. So when I saw that, I'm like, what is a star chamber? And that goes way back to Britain and, So I would say that if you're having meetings of the officers and the superintendent at one of these conferences, that could be considered a star chamber meeting, such that business is going on not within a regular school board meeting, and not just to plan the agenda.
Should meeting notes, minutes be kept of the board officers meeting?
You're not required to have minutes. Just like executive session, You were not required to have minutes of the board officers meeting with the superintendent, and you're not required to have them during executive session. So if you were going to do that, for board officers meetings, you would need to have that within your policy, because the law doesn't require that. It simply requires meetings of public sessions of the board. And another question I get a lot is, how detailed do those minutes have to be? They don't have to be particularly detailed, all right? They need to, of course, record what a vote was, and who voted yay, and who voted nay, and whatever the general topic is that was voted upon. I've got a lot of my boards who have started keeping detailed minutes and requiring the board secretary to do that, where it's almost a verbatim transcript of what was said at the board meeting. And I think that's a problem for a number of different reasons, particularly if, as you do, you live stream your meetings where anybody can go and watch what actually was said. That's the best evidence of what was said, as opposed to what somebody is writing down, with the minutes. But something else that's interesting, when you look at the FOIA section on minutes, is that a trustee can ask that an item be added to that a comment be added to the minutes. So if you, as a board member, if you believe that the minutes did not reflect what you said, or if there was something that you said that you believe needed to be reflected in the minutes, you can ask that that be added to the minutes as what you wish to be added. Yes, ma'am.
I was just gonna go back to the public body. So if we have a committee that we put together and only have 2 board members on, it's still considered a public body. Even if we don't take action, we just present the findings back to the board.
If the findings come back to the board, it doesn't matter how many board members are on it. If it's coming back to the board, that's an advisory committee to the board. And in fact, if you look at the definition of a public body under FOIA, it talks about committees, subcommittees, and then it uses the phrase "and the like," okay? Which again means to me that a court, in almost every circumstance, if they're faced with that question and the information is coming from that committee back to the board, it's going to be considered a public body.
Okay, so the superintendent can have committees that don't have any board members on it, and that's not foiable. But if the board member lands on it, it becomes foiable. Is
Yeah,
that
I would say if a board member is on a committee that the superintendent is calling, that's going to be considered a public body for purposes.
So you see a love-hate relationship, because we won't have any committees with board members on it, which we don't right now. We won't
Right.
probably, and we're always fighting for information. So is there not any way for us to?
Well, there's nothing wrong with forming committees. What you have to keep in mind is that once you do that you have to follow, if it's going to meet the definition of a public body, which in most cases where you as a board member are sitting on that committee, and it may be with members of the public, right? But you may be the only board member on there, you have to comply with FOIA.
So we
Okay.
probably have to record it and
Yeah.
tell
Well,
everybody
and-
about it ahead of time. and
Yeah, you have to
agendas.
give notice of it, you have to have an agenda for those meetings, right?
Even if it's just one person and they're not acting in capacity of the board necessarily, they're just going to be reporting back. So, do you see the problem here? There's a love-hate relationship. None of the board members, because it would be simpler not to have to record and send out agendas and all that ahead of time, none of the board members will be on any of the superintendent's committees. So not, unless we demand it, and it's kind of, that creates a back and forth power struggle. So I just
Isn't
wonder.
a committee, I'm just curious, but wouldn't you have a committee to have another group of people to report information back to you? I'm just curious.
Yeah, but a lot of times, well, sometimes you want the board member to be on that committee, sometimes, because that way there's more information given to, because that's one of my love-hate relationships with FOIA, is I feel like because of FOIA is so strict, we get no information, none. So it's so tight that we get nothing, and so how do we get information?
Well, I think
So-
that gets into the trust and communication that you have with the administration, right? I think that's where, if you feel like, as a trustee, that you're not getting information that you need in order to be able to make decisions, right, on behalf of the constituents of the school district, right? Not just Lexington County, not just Richland County, but for the whole school district. That's where you need to build trust with the administration that you're getting the information that you need.
Yeah, but
Right.
if they feel like everything's gonna be foiable, they're not gonna really share anything that they're not willing to share with the WIS guy. It puts everybody in a position where there's no ability to actually have full disclosure about what's going on, because, we have to be careful about what's being said, but there are times when, isn't it possible for us to share information in an executive session setting?
If it's appropriate for executive
Right.
session, yes.
Because
If
it's
appro- but at
personnel,
a
or
meeting.
it's about students' personal information, or things like that, so.
Right.
But we can't do that via email, we can't do that in committees, we can't do that in any way at all, except for executive.
Well, if there was a committee of the board, okay, let's say there's 2 board members on the committee, and then there's 2 parents, and there's 2 business people, and a couple of students, okay? And that committee is formed for the purpose of studying, with a pandemic right now. I know y'all are dealing with reentry plans and all that, so it's probably not a good example to use. But let's say, let's use my example of school closures, okay? And so you've asked for this group to meet and to report back to the board on what their findings are. That committee has to, abide by FOIA as far as giving notice of their meeting and having minutes of the meeting and so forth. Now, that advisory committee, if they wanted to go into executive session for a purpose that is allowed under FOIA, they could do that. So they would operate the same as the full school board, if that makes sense. But again, I think as far as getting information that you feel like you as a trustee need to be able to do your job, again, that gets into the trust and communication between the administration and the school board. And when you address that is, if you feel like you're being stonewalled all the time to address that is when you evaluate the superintendent. I mean, that's one of the things that you evaluate is, do we get the information that we need in order to be able to make, intelligent decisions on behalf of the school district. So, committees can be good, but again, I think if any committee, no matter who is on it, is going to report information back to the school district, it's going to be considered a public body and you have to comply with it.
Unless there's no board members on it.
No, even if there's not any board members on it, okay, let's say it's 2 parents, 2 students, 2 principals, and 2 members of the community, but they are going to present information back to the board, they have to comply with
But if
FOIA.
it comes through the superintendent or through, say, Dr. Harris or somebody else, that's not the same thing.
That would be different because it would be coming, you want to speak to that, Christina?
I have a relevant example that you all dealt with recently, the committee for Piney Woods Elementary. By policy, the chair of the board was able to either participate or have a designee. So the principal of Piney Woods Elementary has come before the board for the naming of the school, the mascot and the colors and things like that. So that's an example. And to use Ms. Gardner's example, we posted the notice that the group was meeting. There was not a board member in physical attendance, but the board had the opportunity to appoint a representative or a designee in lieu of the chair's participation. So that's an example of an outreach of a committee that I think will be a relevant example that this board has seen in operation recently.
Well, how was the reentry boards, or how was that different? Because it didn't go the same way. So how was the reentry advisory boards different? Because their meetings were not held that way. So how is that different? That's all I'm asking.
Well, and I'd have to know all,
Yeah,
you know what I'm
I know.
saying? I mean, I'd have to know all the details to know, but
That was when the powers were taken away from the school board and given to the superintendent. That's
Yeah,
how that.
But they're still meeting, and that's.
Yeah.
But if we could, let's keep it, I mean, that may be a specific thing that Ms. Gardner could
I'm just
ask
trying to
you.
figure out, how do we get pertinent information that we need? Because like I said, I wouldn't want her to share something with me that she has to share with somebody on WIS if it was sensitive. So how do we have the ability to get that information without, but the only thing that we're allowed to talk about is personnel and contracts. So I'm just curious, like, it actually does cripple us to be able to make decisions at some levels, so.
well, and again, I think that gets into the communication about if you want information, you send the request to her and then she sends it out to everybody unless it's gonna take a whole bunch of time and then it comes before the full board to vote. And we can talk in more detail about that, but.
Can I ask one question?
Sure.
Just because we go through all this stuff for
Right.
these meetings, but if the board has a committee, you don't have to have live stream and video. I mean, you just have to have minutes
You have to
published.
have notice posted, an agenda 24 hours in advance, okay? And you have to keep minutes. That's what, you don't
And the
have
public
live
does have to be
streaming.
invited.
Yes, yes.
Okay,
Yes, the
gotcha.
public has to be invited, the notice has to be posted, and you must have an agenda, right? And you must keep minutes. But other than that, it doesn't have to have the live streaming and so forth.
Does that go for any workshop or anything like that? Would it not have to be live streamed, or is that just for committees? I'm just curious.
Well, that really depends on, nothing in the law requires you to live stream, okay? So that's driven by your board policy. And now in times of COVID, and y'all may have been live streaming before the pandemic, I don't know if you were or not. But, you know, the School Board Association advised school boards around the state to have some way, you know, even if the public could not physically come into the room, that they be able to, because FOIA requires that the public be able to hear what's going on. They don't have to, because I remember the School Board Association speaking of this, that there's nothing that requires that they be able to see, okay, everything, but they have to be able to hear. But districts that have the ability to do live streaming have chosen to do that so they can both see and hear. So, what about texts and emails? Are those considered public records that you send from your phone or from your laptop? They are.
Yes.
Okay, so be aware that if you are texting about school district business, or you're emailing about school district business, or you're Facebook posting about school district business, and you get a FOIA request for that information, we, lawyers and the superintendent, are going to come to you and say, I need to see all of your text messages, so I can see which ones we're going to have to disclose. There are penalties for FOIA violations. Interestingly, depending upon the circumstance, there can be criminal penalties for FOIA violations, which is pretty interesting to me. And then, of course, attorney's fees and so forth. And in the most recent amendments to FOIA, it states in there that if a district is receiving repetitive, burdensome, and oppressive, I think is the language that's used, FOIA requests, that the district has action that they can take against the requester. Now, having said that, I would say that before you do that, I would think long and hard about the ramifications, right? Of saying to someone, we're not gonna respond because we believe, because that's just gonna set the tone right there for whatever your relationship is with that person or with that news media. But it is now in the law that a public body can do that. We talked about all this as far as FOIA agenda requirements. These are, and y'all spoke to this a minute ago, personnel or student matters, contract negotiations, legal matters, but only if they relate to a pending, threatened, or potential claim, security and safety measures, and investigative proceedings related to criminal conduct. Let me say this, are we okay with time? Are y'all okay? I see a lot of executive session drift. Do y'all know what that is? Right? You get into executive session for the purpose of discussing personnel, okay? And let's say it's something related to whether or not a certain employee should be terminated. Well, in the executive session, you then start talking about something else that is not why you went into executive session. Let's say you start talking about a land purchase, okay? That even though a land purchase can be talked about in executive session, when you went into executive session, you didn't state you were going in there to talk about potential employee termination as well as contractual negotiations. So what have you done? You violated FOIA. Another time that I see, and who should police that? The chair. Right, the chair should be the one to say, I'm sorry, you know, that we cannot have that discussion in here. We came in here for this specific purpose. We cannot talk about that. I've also seen boards, they go into executive session to talk about a specific employment matter, which they can do, and then in that discussion, they say, well, while we're in here, you know, let's talk about whether or not we should give a salary increase to our bus drivers, or whether or not we should, you know, something along those lines. That's not appropriate for executive session. It can't just be personnel in general. It is certain personnel matters related to employment, termination, discipline, salary as it relates to a specific person, but not a group of people. So that's something to keep in mind too. Okay, I'm gonna turn this over to Scott to talk about the code of ethics, and then if y'all want, we can get into we've talked about some of these landmines, we haven't talked about all of them. We can either keep on this evening and do that, or if y'all don't want, we can reconvene. We're happy to do it however the board wants to.
We're almost to the last.
It's a long meeting.
Okay. So if y'all wanna take a break after Scott, before we get into that, we can, we'll just let y'all decide, so. Here's your clicker.
I have asthma, so if I cough every now and then, please don't be alarmed. I wouldn't be here if I thought it was anything but that. Yeah, so thank you for having us. First of all, thank you for the work you do. I think you kind of said that, but my point of reference, my father served on the Marlboro County School Board. We discouraged him from doing it, and he did it twice, and he was good at it.
Yeah.
A really cool, nice guy with no real agenda. So he was good at it. And but gosh, it is I think a thankless, difficult work. I think if I'm not mistaken, Jimmy Carter said that was the hardest work he had to do in the school board. So yeah, at least I want to recognize that for y'all. So yeah, just a little bit of background, and I'll just kind of piggyback on what Andrea has said a couple of times throughout this, which is trust and communication. Unfortunately, while I was at the department, I had the pleasure of being intimately involved in occasions where the dysfunction within the district was significant, and it wound up in the framework of unprofessional conduct case against superintendent. But the takeaway there, and I'm going to lobby at some point to put this clip into our slides, is a clip from Cool Hand Luke, where the warden hits Paul Newman and he rolls down, and all of the inmates are looking at the warden, and he says, "What we have here is failure to communicate." And so many times, I would even send that clip while I was I've sent it here while I was with Light and Story, and I oftentimes send it at the department when these issues come up, and it can really boil down to that. And it is about information and openness, and the rules are to protect you. These, obviously, Andrew knows them backwards and forwards, but the rules of engagement here about collegiality, about professionalism, really protect the process. And it's going to be impossible for anybody in a contested setting to avoid contested matters and avoid wounded feelings and that sort of thing. But if you stick to the rules as best you can and be mindful of continuing to openly communicate, I think that's the recipe for success. So, ethics. This is a whole nother realm for you. We present to principals, the principal induction, so they're trained that all principals have to go through. And when we get to this section, there's a slide that I use that says, if you don't want to see it in the newspaper, don't do it. That's really, to me, the measure. But it's worth reading some of this, so I'll be really quick, mindful of your time. But section 8-13-700A, use of official position or office for financial gain, disclosure of potential conflict of interest. Okay, no public official, public member, or public employee may knowingly use his or her office, membership, or employment to obtain an economic interest for himself, a family member, an individual with whom he or she is associated, or a business with which he is associated. This prohibition does not extend to the incidental use of public materials, personnel, equipment, and so forth. So it's pretty broad. I think it's interesting, even if it's someone with whom you're associated, you have to be careful. The next section, that was 700A, this is 700B. Public official, public member, you guys, in the discharge of your official responsibilities are required to take action or make any decision which affects an economic interest of himself, a family member, an individual with whom he's associated, or a business. You must prepare a written statement, and you guys may be used to this, describing the matter requiring action or decisions and the nature of its potential conflict of interest. As a public official, if he is a public official other than a member of the General Assembly, shall furnish a copy of the statement to the presiding officer, the governing body of an agency, commission. So these are matters for which you have to recuse yourself. You may have had to do that already, but again, the really critical piece is you have to attach this to the minutes. And if you do not, the Ethics Commission will come and get you. So we'll get, so I want to get to the landmines here, so we'll kind of go through some of these, but here's some questions for you to ponder. What are the rules for a board member who has a family member employed in the district? We can kind of touch on some of these. What are the rules when a board member is invited to a dinner by a vendor currently doing business with the district? That may be incidental. What are the rules when a board member is invited to a dinner by a prospective vendor? And what type of gifts is a board member required to disclose? You need to know that? What type of gifts you're required to disclose. There you go. Yeah. And I think, again, not to oversimplify it, but with the newspaper analogy. But if you have any question, anything over the price of a cup of coffee, report it. Report it. You all, got into this business. It's public service, and you don't want to, just inadvertently fail to report something. It's out in the public. It gets misconstrued in the public, and then you are viewed as if you were, a grifter. Another question: if my spouse is a teacher, must I recuse myself from voting on salary increases? Vigilant.
What if it's across the board?
If it's an item that deals with the entire budget, you get to recuse yourself then?
I thought not.
Correct.
Yes.
You don't, yeah, I would.
I would.
But you're not obligated to do that. It's only if it's an individual or a smaller class of individuals, like if your brother is an assistant principal and there's going to be an increase for assistant principals, then I would certainly recuse myself from that. But if it's just an overall increase that's within the budget for all teachers, then you don't have to, but a lot of board members will do that.
Do you mind if we just address the question, what's the difference between a current vendor and a prospective vendor? Would the rules not apply to both? I mean, there are different rules.
There are different rules. So if you are currently working with a construction company or a law firm or an architectural firm or a CPA firm, then you may go out to dinner or go to the football game with free tickets, whatever it is that's being offered to you by that current vendor, without violating the ethical rules. You must, however, report the value of whatever it is. If it's a $200 football ticket or a $100 meal, you still must report that, right, as a gift. But if you, so the rules as far as prospective vendors, if you have an RFP out, or an RFQ out, or a bid, an invitation to bid out, okay? And it is for, let's say, cleaning services, janitorial services. You're looking at outsourcing that, right? And then a company that is in that kind of business wants to take you to dinner, you cannot do that, okay? You are not allowed to go to dinner with that prospective vendor. If you don't have an invitation for bids or an RFP or an RFQ out, and you're asked by a construction company, right, to go out to dinner with them, you can do that without violating FOIA. Again, you still have to report it as a gift. However, I would discourage trustees from doing that. Does it violate the Ethical Act? No, it does not. But if you do that and you're observed doing that, and let's say you've got somebody in the community or a fellow board member even, or a former board member or an adversary who ran against you in the election, and they find out that you did that, they may report you to the Ethics Commission. Now, ultimately, you may be found not to have violated the Ethics Act, but just, I advise, don't put yourself in the position of that occurring. So it's definitely prohibited if you have that RFP or invitation to bid out. It's permitted
for sure, if it's a current vendor, if it's somebody who is looking to do business with you, but you're not in the process of actively looking for that kind of business, you can do it, but I would just be cautious about that.
We have, in the procurement code, there's items that don't require an RFP or
Correct.
RFQ, like legal services.
Right.
So in that case, where would that fall?
Again, it would not, if you go out to dinner, if you're invited out to dinner by an attorney or by a law firm, and y'all have decided not to go with the RFQ process, right? You could do that. You would not be violating the Ethics Act by doing that. Now, however, if you would send out an RFQ for legal services, even though you weren't required to do that, the fact is that you did it, so I would not, I think that would be a violation of the Ethics Act then to go out to dinner.
But you still have to report it.
You still have to
And
report the
either way.
value, no matter
Right.
what you do, you got, now, do you have to report, like, during School Board Member Appreciation Week, you get gifts from each school? You don't have to report that kind of thing, but,
Any honorarium.
yeah, that's considered honorarium, that you don't have to report.
These are tough questions. I always think of it, and maybe I'm wrong, but the rationale seems to be, you have a vendor that's a current vendor, and particularly in these small communities, you're gonna know these people. You're gonna know that my sister or my brother is a jam-up principal, and they need to be there, and they're in the community. And so, while you may not need to vote on their employment right, individually, but they're part of the process, that's okay. You can't help that. You're not committing an ethical violation because you're related to this great principal that needs to be hired. Same with a vendor who you may know, just have to be careful, keep reporting it. I think a lot of what you see in the news is the failure to report.
Yes.
And there's just not a good look.
Well, and then filing your statement of economic interest, you have to do that. And you have to do that whether or not, you've gotten any contributions and so forth. You have to file that. And what happens with board members, they don't do that, right, because they forget or they think they don't have to because they don't have any contributions. And then those fines that you get, they start on top of each other, they start adding up. And it may have been a totally innocent thing, but, once it starts to add up like that, and it's $15,000 worth of fines. And the Ethics Commission, they're pretty serious. In fact, I had a situation, I can't even remember what the details were, but it was with one of the Lexington school districts, and it was about a teacher, whether or not they were using their official position for personal financial gain. They had a side business that was related to what they did for the district, and they were encouraging their students to utilize this side business. And so when the investigator came and he was meeting with people in the district, the superintendent wished for me to be there for employees who wanted to have me there. He had a gun, and I'm like, you're investigating for the Ethics Commission and you've got a gun? But again, there's criminal penalties, and so forth. It surprised me, but they take that stuff really serious.
But they're also very available, I would
They
say
are.
as well. That is one thing. I think they're scary, but they are also public servants. It is their job to answer your questions. Just like if I pick up the phone and call their general counsel, you can too.
Yeah.
So,
And I encourage you to do that.
that.
If you have a question about yourself and whether or not you should do a particular thing, call and ask. And also districts can ask for, individuals can ask for advisory opinions from the Ethics Commission, under these facts and circumstances, would this be a violation? The other thing about ethics is that if there is a complaint, it is not allowed to be discussed until it has been resolved. And if that is violated and somebody speaks out and says, well, I know that an ethics complaint was filed against so-and-so, that's a violation right there for that person to have admitted that there is, shared information that there's an ethics complaint. So be aware of that as well.
Just two quick thoughts. Totally agree on the asking questions. Kathy Hazelwood, former general counsel, that's
Yeah, she's really good.
And she's excellent.
Scary when she was.
Yeah, I worked with her for 5 years. So she's tough. She'll give you a straight answer, especially if she knows it. She will know it. But she's also at the Department of Ed, so some of your questions may overlap. Ask her, call her. Of course, you can call the Ethics Commission. But more broadly, I think all of these issues that we've talked about, just stop and ask. You know, that to me is really important. I've seen meetings where a motion is on the table and the group doesn't seem to want to vote on it, but there's not enough discussion when everybody's looking at everybody else to see, should I vote on this motion or vote it down? Because they're going to, you know, just talk, just use words, and you'll be better off. Got two more, and so we'll get you out of here a little bit. Other landmines. Allowing your role as a parent, spouse, grandparent to overlap with your responsibilities as a board member. And in reading this, again, I think of stick to your rules, stick to your duties and your obligations as a board member. Think about those. You cannot, again, jury, you can't leave your common sense on the street when you walk in here, and you can't leave your personal experiences behind. You know, as a teacher, you know, you have a certain expertise that you are bringing to the table. Bring it to the table. You just don't want it to overlap or.
And where I see that as a problem is if you, let's say your spouse is a teacher in a particular school, and you go to take them lunch, right, and in your role as a spouse. But then while you were at the school, you say, you know, I've been hearing that there's not a whole lot of supervision in the lunchroom at this particular school. So now I'm going to go, and I'm just going to go check that out for myself, and I'm going to walk around and monitor what's going on, or I'm going to go down to this teacher's classroom and see what's going on down there. You can't do that. There is a protocol for visits to school as a board member. So, you know, you may say, but I'm here as a parent, but you're also a school board member, and you're going to be viewed as such. And so if the principal sees you walking around and peeking into classrooms and so forth, what's the principal going to do? She's going to call the superintendent and say, hey, this board member was at the school, you know, yes, her spouse works here, but it appeared to me that she was going around and investigating what's going on. And remember, when you're outside of a board meeting, what? You don't have authority to be doing that unless you're visiting the school pursuant to the board policy for trustees visiting the school. So just keep that in mind.
And I'd like Dr. Melton to say for our new members, I know schools welcome a school board member, but there's a protocol to it if somebody wanted to visit as a school board member. Would you share that?
Yes, ma'am, we actually have a policy for that, Andrea. I did not have that one pulled up, so that may be one that we would like to note to review, Ms. Hammond.
Okay.
And Andrea, I think you and your team would likely add, the role of the board is so important, and you all can be so intimidating even when you don't want to be. So when you walk into a school, the staff's response, you may not be investigating as Andrea described because you're there out of curiosity, but you could be perceived as investigating and the kind of climate that could lead to. So Ms. Hammond, I appreciate that. If we could find that one and note, or maybe we can owe that one to you, Ms. Hammond, to follow up. But there is a policy that we need to make sure that is in operation.
BBA, I think. I think it's at the end of BBA.
And Dr. Melton, I appreciate you addressing that, especially for new members, because you might want to visit. It's like she's saying, they want to think we're interested in the schools and that we will take our time to visit there. But you know, you're going to let the principal know. They're going to know you're coming and where you're coming and the time. But
Then you sign in too.
Right.
You know, just like any visitor to the school, you would sign in and then go with whatever it is you wish to do.
I have a question, Dr. Melton, and I do have that policy up. Kathy was right. I have it memorized. The policy says that board members should make official visits to school only under board authorization and with the full knowledge of staff, including superintendent, principals, and other supervisors. So does that mean that we can only visit schools as a group, or can we notify the board that we want to go, you know, one or two people so that we can? I'm just curious, and obviously probably not right now because of COVID, but I'm just curious of what that policy is.
I'll just speak to it, not with what your policy at this point necessarily says, but just from a practical perspective and what most districts do, is that no, you wouldn't have to go as a group, right? So if you, let's say you wish to go visit Spring Hill High School, right? What you would do is you would notify the superintendent that you wish to go visit Spring Hill High School and that you would like to do that the following Thursday afternoon at 2 o'clock. So then she would notify the principal so that the principal knows to expect you to arrive at 2 o'clock. And then you would go and you would sign in, and the principal would greet you.
And I think it's important and proper protocol for the principal to accompany you as you go to this particular classroom. Because if you're going around by yourself, again, I think you're gonna have the staff thinking, wait, what is this person doing here? Why are they in my classroom, or why are they? So you would have the principal, come around with you. If you didn't wish for some reason for the principal to do that, I think that's a discussion you have with the superintendent.
Absolutely.
That-
Well, I was just asking because I've visited schools in a professional capacity before being on the school board, and it's easier to walk around with the principal and ask questions one-on-one or two-on-two than all of us like swarming
yeah.
a principal.
And that may be appropriate at some point if
Right.
we visit, but yes, I think it's
I'm just
important
curious.
that, and going back to that first slide that we had, one of your powers and duties is to visit the school.
Right.
Right? And so you have the right to do that, and you should be doing that, but you want to do it in a way that doesn't disturb the educational process and doesn't put the principal in a position where, she or he feels like you're there to somehow get them, so to
Right.
speak.
And there are situations where there may be conflicts on calendars.
Yes.
As an example, we meet consistently with principals on Wednesday. So you may request to go on a Wednesday afternoon at 1 o'clock or 2 o'clock. That may be convenient for your schedule, but that would create scheduling disruptions. So we would then have to determine, is the content what we need a principal's representative for that meeting, or could a principal send a designee to that meeting to be available for the visit? And in a normal year, there are invitations, this time of year especially, where the board's going to get invitations. So that may be of help to describe how to respond to that, because our board has been very visible. In a normal year, when there's festivities and things that are happening, of programs that are student-led, that they want to see students and have the chance to intermingle, and that's different than a quorum too. So when
Yeah,
things
if you're
return
doing
to.
that, if you're invited to come to a school, you don't have to go through the notifying the superintendent and going and checking in and so forth, because you've been invited to be there by that particular school. Where the process of notifying the superintendent that you're going and then following the protocol is when you just want to go visit a particular school, not pursuant to an invitation. And I know in some districts, they got a policy where the superintendent is required to go with the trustee. Which, again, I don't think that's necessary. But just notifying the superintendent so that the superintendent can let the principal know. And always, always sign in when you're there. That's for protection, just that you're in the building. If something was to happen, if there's an intruder or there's a fire, they need to know that you were in the building. Do you have a question, Kathy?
No.
Okay.
Real quick, just more so for clarification, Dr. Melton, what would you consider an ample notification time if we wanted to visit the school, giving you a heads up to allow the proper channels of communication to happen?
I don't know that there's a right answer for that. We, of course, know that there are schedules we need to look at. The principal may be on leave for professional development purposes, may be on leave for sick leave. So short notification typically isn't successful notification. But I wouldn't ask for something to be an extraordinary amount of time either, because you may find out on a Monday that you have time available on a Thursday. That would be appropriate. But it just depends, I think, on the circumstances that may be occurring. So I would ask that we not have notification at 8 a.m. for that afternoon at 1 p.m. and the awareness of the amount of time that you're there, because you're going to enjoy the conversation. You're going to enjoy the visit. But as a disruption of the educational environment, there's also a distraction from the responsibilities of the location you may be missing, of just keeping it respectful that our folks have a lot of things to do, and you're going to enjoy your visit, want to stay longer than maybe you intended to stay usually. It's hard. I have exit issues. I have a hard time getting out of places because I enjoy being there so much, but that's because of me, not necessarily because of where I'm experiencing for the visit. Andrew, anything you would suggest as far as a...
Maybe 48 hours. Might be a reasonable period of time. And I always like to use in policy words like generally in most cases, so it's not just always 48 hours, but, generally speaking, a board member would give 48 hours notice to the superintendent of their wish to visit a school.
Well, in the school day too, they want to do it at 3:30.
Yeah.
It's a whole lot, maybe not. I don't
That's
know.
dismissal for most schools. I would not encourage you to be there for dismissal.
Right. It depends. It depends. When the students are there, when it's less stressful for somebody. I've been in many, many schools And I would have a badge, and I would try to make it as easy as it could be. The State Department's coming. And I thought it was, personally, I thought, well, how would you look at me like that? Just tell me what's going on. And it didn't take long, and you break down those barriers. But I would say, seeing, and I know I'm not too preachy here, but site visits in every aspect of life are important. The law business, the school business, just go and look and see it. It makes a difference. I don't want to get off the subject too much, but Andrew mentioned it. We can talk about it in more detail if y'all want to. But one of the things that comes to mind in terms of the schools that were taken over by the department, in some cases, because it related to dysfunction. In some cases, it related to governance dysfunction. In other cases, it was a combination of things. It was finance, it was special ed funding and appropriateness, and it was governance. But one thing that does come to mind, one particular district, it did relate to a board member, a couple of board members being too heavy-handed, being too present, not following the protocol, and it caused so much disruption that was kind of part of the larger scheme where the board was out of control, and it really led, partly among many factors, to the takeover by the department.
Because the department does, and let me just mention this too, Title 59 it contains all of the laws related to education in the state of South Carolina. And you can access that on South Carolina General Assembly online, and you can also access Department of Ed's regulations. Is that 33? Is that the code volume? 58, that's right. So you can find those, and so, if any time you want to go read all the various laws and so forth, it's interesting to do that. And FOIA is in section 30, so in Title 30. So that's another place you can go and just read for yourself what the law says.
And it's pretty easy to word search, depending on what you are looking for, you can find it. And it's there.
And it talks about takeovers by the State Department.
It does, and they are rare, but I think, again, I was participated in Williamsburg, Lawrenceville, I think Sumter's finances were taken over for a time, Allendale. And one thing in the Allendale thing, and I know this is live stream, so I'll be a little careful, but two of the items, and I communicated with the lawyers, it was going to the Supreme Court, and I got a hunch that there was some sticking point with the board. The board is obviously, the board powers have been basically taken away by the takeover. They were trying to challenge that at the Supreme Court. And I knew the lawyers involved, and I said, ask what they want. And one of the issues, and I won't go into more detail, it related to travel. And it seemed, it wasn't really, it was something somewhat more trivial than you would imagine. And then once that little tiny issue was resolved, no longer are we going before the Supreme Court. Like, okay, you guys can come and take over, we'll play nice. But it can get kind of petty, and I think the takeover, and that's at that time was the proviso, so provision in the budget that allowed the state superintendent to do that. Again, that is rare. It is not going to happen here, but it is instructive in the broader scope of what you guys do. All right. Failing to maintain the confidentiality of matters discussed during executive session. I'm sure Andrew's got some more stories there, and that's important.
Well, let me just say, there's nothing in state law, in Title 59, that says that if you violate the confidentiality of the executive session, you go out and disclose something that was discussed during executive session, that there is some penalty for you as a school board member. Now, it is in the oath that you take, and if you read the School Board Association Code of Ethics for School Board Members, it talks about the duty that you have to maintain confidentiality. But what's the potential problem for you if you do that? Besides being censured by your fellow board members, what's another possibility? That you could be personally liable for if you're repeating potentially slanderous information. So, for example,
if the superintendent shares with you during executive session that she is in the process of investigating to determine whether or not a teacher is involved in an inappropriate relationship with the student, and she just tells you that as information, so that if you see something about it on the news, let's say the teacher has been arrested, right, that the district is working with law enforcement and conducting its own investigation. If you go out in the community and you say, hey, you know, our district is investigating this person, and I've heard that he has, you know, female students in his office at all hours behind closed doors, and then later it turns out that it was all mistaken, that it was not an inappropriate relationship, that teacher can do what? Turn around and sue you for defamation, for repeating false information. And generally speaking, you all have immunity from suit, okay? The law provides you with immunity from being sued if you are carrying out your powers and duties as a school board member. But if you go and do something like what I just described, okay, and you're out repeating that information, you lose the immunity that you would otherwise have under the law. So it's important for you to, that's another reason for you to maintain the sanctity of executive session, is you don't want to personally be sued, and then the insurance that the school district carries on all of you, it's E&O insurance, errors and omissions, that the insurance company says, I'm sorry, you were not acting within your scope of duty as a school board member, so now we're not going to provide you with legal representation. But, you know, you may see at some point a lawsuit where you are, the board is named and it names all of you, but let's say it has to do with closing the school or rezoning, right? And parents are upset, they don't feel like you follow the law and so forth. You are not going to be personally responsible for going and hiring an attorney. And if there is a verdict against the school district, you're not going to have any responsibility for how you voted on that particular matter because you are immune. But it's in these other cases where you step out of what you're supposed to be doing as a board member that you open yourself up to liability. Does that make sense to everybody? Yes. And then on here too, failing to accept the vote of the board majority, okay? That is in, again, the code of ethics for school board members. You all, when you're in a board meeting and you're debating an issue, right, and then the vote is on the issue and you're on the losing side of the vote, that decision of the majority of the board becomes what? It becomes your decision, right? And so from a ethical, and when I use the word ethical in this regard, I'm not talking about the Ethics Act. That's something else entirely, but I just mean generally speaking, ethically. If you're out talking about, well, that wasn't my decision, I voted against it, and you know that board is so sorry, and you're not in adhering to the code of ethics that the school board association has put out. The time to debate those issues and say your piece is during the school board meeting. Then when the board votes, you know, you're on the losing side, and I think that's what you would say if you're asked by somebody. Well, I shared my opinion and I voted how my conscience told me to vote and what I thought was in the best interest of this school district. The board chose to vote in the other direction, and so now, you know, I am going to do what is necessary to carry out the vote of the board majority, whatever I need to do as an individual trustee. So, you know, that's how boards work in a functional way, as opposed to becoming dysfunctional. And then the part about a board becoming dysfunctional is if you have to go out for a bond referendum and you have been dysfunctional over the years, that's the immediate thing that the public's gonna pull up. Why in the world would I vote for this school board when they can't handle this issue? Why would I trust them, you know, with a $35 million bond referendum? So just something to keep in mind.
Well, and you hit it. I was just gonna say, it's in your best interest to not go out and badmouth after, as just as Andrew said. Do it in a collegial way, in a proper way, in an accurate way. That way, the next time an issue comes along, whether it's a bond referendum or some other issue, you won't have broken the trust among your board members, and you can come back together for the next issue, and the next, and the next, and the next.
Right.
It's just that. It's in your best interest to do it.
You want to flip to the next?
That's
On here, we talked about lack of communication, so we don't really need to belabor that anymore. You know, board members acting individually and not as a group, we've talked about that your power lies in your being a member of this body, not you individually having any power outside of this boardroom. coming to board meetings unprepared, it's the superintendent's job to get you the information that you need to make a decision. She has a duty to do that, and then it's your duty to what? To read it, and not come to the board meeting and be flipping through, trying to figure out what you might want to ask. You have a duty to come to the meeting prepared. And again, if you feel like you don't have the necessary information to make a decision, then you ask her to provide you with that information, and then she provides that information. This one is big, playing gotcha at board meetings. That doesn't serve anybody well, and that's the case with the superintendent doing it to the board, and the board doing it to the superintendent. It works both ways. And all that's going to do, again, is make the public look at you and say, can y'all not get your act together here? You're gonna have differences of opinion. You're not gonna vote for everything she recommends, and she understands that you're not gonna vote for everything that she recommends, right? But don't come to the meeting. I mean, if you've got a question and you really feel like you need the answer to that question, ask it before the meeting, right? Don't wait to the meeting and then, again, spring that question out in front of the public in an effort to make the administration look bad. Same thing with the superintendent. I would say, don't spring something on the board at a meeting so then the board looks bad. That doesn't do anybody any good. So really try to get your questions answered and for her to get the information to you so that when you come to the board meeting, you may have a difference of opinion, but you're not playing the gotcha game. Overlapping of administrative responsibilities, I guess the phrase I like to use is know your lane and stay in it, know what is within your authority and responsibilities and what is within hers, and try to stay in that lane. Because when you do that, it's what you're supposed to be doing as a board member, but it also protects the school district from liability and it protects you from liability. Giving orders to employees.
I have a question about that, because it's not always black and white.
Right.
And when sometimes, let's just, an example, we get a lot of emails from a bunch of parents about X, and it's clearly an administrative responsibility, and we pass those along. I mean, I think that's what we should do.
Right, it is.
Does it ever get to a point that we do feel like we have to address it, or it's just?
Here's what her contract says, and here's what board policy says, is that if you, and it's without regard to what the question is, okay? Whether it's from a bunch of parents or a bunch of teachers, whatever, you are to forward, if it's something that is an administrative responsibility, like day-to-day operations of the school district, you refer that to her. And then what her contract says is that she will investigate, right, whatever the complaint or the concern is, and then she will report back to the full board as appropriate, okay? And so that phrase, as appropriate, gives her the discretion what to report and how to report it. That's how her contract is worded. But if you reach the conclusion at some point that you feel like when you send something to the administration for her to look into it, and then you never learn, right, in your role as a board member what happened, and that seems to happen over and over again, and you're still getting the same concerns from the same group of teachers that, well, I've not heard anything from the superintendent. Don't say, well, I will fix that for you. You can't say that to parents or teachers or anybody else because you don't have the authority to fix anything. But you bring that up with the superintendent, again, as part of her evaluation. And y'all have the authority, in addition to conducting a formal evaluation of her, at any time that you feel like she's here and y'all are here, and it's come to kind of a stalemate with regard to information she's sharing with you or information that you're sharing with her, y'all need to have a discussion about that, right? I mean, there needs to be, and that's a discussion that can take place in executive session as to, hey, let's sit down and let's look at what are the goals for the superintendent, what are the goals for the board, and how can we work together to try to see that those goals are accomplished. But you cannot, it is not your job to, for a number of different reasons, that you go and investigate and try to fix things in the district that are within her purview. And another reason for that is, let's say you're getting a complaint about a teacher, right, about how a teacher is interacting with students. Well, that teacher may be recommended for termination ultimately by the superintendent, and you all have to hear that. But if you have been involved in investigating it and discussing it and so forth, you're gonna need to do what?
Recuse yourself.
Recuse yourself from that. Can the full board make y'all, the full board or a majority of the board make a member recuse themselves? No. No. It's up to that individual trustee to recuse themselves if they feel like they have a conflict. Now, if they don't, the lawyer for the teacher can make a huge issue out of that and try to disqualify the whole board from hearing the teacher matter and have a court hear it. I've had that happen before too. So, if you're advised that it might be in your best interest to recuse yourself from sitting on a particular hearing, it's your decision, but you need to listen to the reasons behind that before you make a decision whether to recuse yourself.
And just a follow-up, I think a lot of the public doesn't really understand the lanes.
Right.
So we get floods of emails. Would it be appropriate to reply, copy Dr. Milton and say this is really a administrative matter, so I've copied
It would
Dr.
be, yes,
Okay.
yes. And to say that, because you don't want to say to somebody, well, I just can't talk to you at all about that. You want to say, well, our duties and responsibilities lie in developing policy, making sure that the administration implements the policy, and then making sure that the superintendent is held accountable. That's generally speaking what your roles are. And so you would say, this is something that you need to direct to, and you try to start at the lowest level. Like if it's a complaint about something in a school, have you talked to the teacher? Yes, I've done that. Have you talked to the principal? Yes, I've done that. Have you talked to the director of secondary instruction? Have you talked to the superintendent, right? And then if they say they've done all those things and that they've talked to the superintendent, then you ask the superintendent, well, did you talk to this person? Right? I mean, you have the right to ask that. I directed them to you, they say they talked with you, or they say you won't return their phone calls. And then you have the right to ask the superintendent, okay, what's going on here? Because I think you're right. I think the public thinks, well, I voted for you, so I need you to fix this. And that's not your job to do that. You will do what you can to assist with a particular matter, but you can't fix a specific situation. You have a look on your face like you have a question.
I have a question, but I'm hesitant to ask it. I'm trying to figure out how to ask it in a general way, but I mean, I know that our district has been all over the place in the news recently. My question about that is, when we were talking about overlapping administrative responsibilities and policy and things like that, I mean, we're a relatively new board. This is the first time we've all been together since we were sworn in the same room. So a lot of things have happened in that 3.5 week period, 4 week period. My question is, I guess, when we pass a motion that is discussing reentry plans, I hate to ask it like specific, but I'm trying not to, but if we pass a motion to talk about how we're implementing school or what the authority the superintendent has or doesn't have, is that motion good enough, or should we have amended policy? Does that make sense? I'm trying to speak very broadly.
It does.
I'm just curious. I want to make sure we're doing things the right way.
It does.
I think
mean, the
there's no
motion
confusion.
itself and a vote, that is direction to the superintendent. So even if it's not stated in policy, okay, because policy doesn't address it, because policy didn't contemplate that this pandemic would happen, right? So a direction that is given to the superintendent by way of a majority vote of the board is a directive to the superintendent for her to then implement that decision of the board. Now, it could be that then leads you to realize you need to amend the policy. But in the meantime, it's her job to then implement the will of the board that was carried out by the motion, if that makes sense. So that's how that works, because a policy can't cover every single possible thing.
Right.
Just like a student discipline code of conduct or a code of conduct for teachers, because people do outlandish things that you could never think of to put in a document that guides certain things, right? Or you don't contemplate that something might happen. But yes, once the board has voted on something, the fact that it's not in policy doesn't mean that the administration doesn't have to carry it out. Okay, well, it is 6:25. Well, let me mention one last thing, social media, okay?
Yeah, oh yeah, because we have some people on
That's a
phone.
big thing.
We know nothing about that
Right.
in District 5.
So, social media is great and it's awful at the same time. And as board members, you all have as we said earlier, you have First Amendment rights, okay? So you can post on social media whatever you want to post on social media. But two things. First of all, remember that if you post something that's out there about school business, right? Or if you're instant messaging with other school board members, you may be violating FOIA, depending on what you're doing. But if you are using your private Facebook page to also communicate publicly things about the district, keep in mind, you're inviting people to be your friends, keep in mind that they're not only seeing what you're saying about the school district, but whatever else you might have on your Facebook page, or your Instagram page, or whatever social media you use. And so you may be sending out something that you don't, or you may be making available something you don't necessarily want the general public to be able to see, including things about your kids, you know what I mean, those kinds of things. So I've encouraged school trustees, if they want to have a social media page in their role as a trustee, to have a separate page, as opposed to it being part of your private Facebook page. And also, keep in mind that what you put out there on social media may turn around on you at some point. You know what I mean? The idea of discourse about matters of school business on social media, I just don't think that's a great idea. Can you do it? Yeah, you can. You have the right to do it. But just keep in mind whether or not that is contributing to the functionality of the board and of the school district before you do that on social media. It's just something to be aware of.
Andrea, I was thinking about this. We've had complaints over the few years, not necessarily now, but of some board members actually being on their phone. And so, in defense of some people that do that, maybe they're on their phone now that so much is on social media, they're getting a message from a teacher that wants to tell them something, or they're getting, maybe they put notes on their phone. People use a smartphone for a lot of things. But I've had some constituents say to me and complain about that over the last several years. And they say, can you as board not have board members on the phone? Because they assume they're not paying attention. Do you think overall would it be wise not to have a phone out? Or do you think that it's a tool for that board member and they're using it to help them in the meeting?
I think that's something that y'all as a board have to decide. I mean, some people who have young children at home, they need
The dance department right now.
they need to have their phone, or if they've got a sixth family member, that they need to have their phone. And I would say in terms of, having your phone out the whole time while people are talking, to me, it's a sign that you're not paying attention.
Right.
Maybe you can multitask, and look at your phone and answer emails and do whatever it is you're doing. But I just think it can convey an attitude of, well, I don't really care what all these other people have to, whether it's during public participation or while another trustee is talking. I think in that regard, it conveys that attitude of it really doesn't matter. I'm gonna be on my phone the whole time.
I do
Again,
think
that's
it's
just
perception.
something I think
Right.
that you would need to have, and again, I think that's just asking people to be respectful of the audience and of their other trustees. But I think telling people when you come in the room,
Right.
you gotta put your phone in the
No.
basket, that's just not, in this day and age particularly, that's just not workable. And
That's how
it's
I
just
feel.
like participating by telephone in board meetings or virtually in board meetings in a time other than what we're dealing with now, in regular times. And I've seen boards set parameters on that, but again, that's something y'all just have to discuss and decide.
Thank you. Are there any other questions, since they got through all of this good information and you guys had good questions? But before we let the experts go, any other question? Be fair to everyone. Dr. Melton, how about you? Anything? And I appreciate everybody's time so much, and also the employees that had to stay here before we got out of here. Thank
Well,
you.
thanks y'all for inviting us. We very much enjoyed being with you.
We're
Stay
adjourned.
through the rest until we get vaccinations out there, right?
And we only ran an hour over.
That's not so bad.
That wasn't bad.